of New York City in an effort to protect their home. We have a program tonight that is focusing on New York City property violations and enforcement with the four major agencies throughout New York City. I would also like to introduce Aaron Jimenez. He's our operations manager and research assistant at the Du Bois Bunch Center. We ask that you keep all mics off, but if you forget that, then Mr. Jimenez will help you out on that regard. Now, before we get to our co-sponsor, we are going to try to make this as interactive as possible. I will do a presentation on just the litigation end and the strategy end on the violations and the overview of the agencies in New York City. And then we have Valerie Samuel, who's an expediter. And this is what she does. She assists people in code compliance throughout New York City and assisting people in resolving the violations. So she'll talk to you about the enforcement and the resolution of certain violations. And then we would like to hear from you if you have any specific violations that you're dealing with in your scenario. You can put those questions throughout the program in the chat and we will get to them. All the attendees are also have an opportunity to have a one-on-one session at our legal clinic at the Du Bois Bunch Center. You can have a one-on-one session with myself, that is on Wednesdays at the Du Bois Bunch Center, either in person or via Zoom, or you can have a one-on-one session with Valerie Samuel. Either way, we will address we will talk about your violations that you have. Okay, so without further ado, I would like to introduce our Yes, and someone put into the chat that please share the expediters contact info. We will share all info for the Du Bois Bunch Center, for all borough expediter, which is Valerie's company, as well as all the agencies information. So you will have all of that and more. You will walk out with handouts, and what you don't walk out with, then we will email that to you, all the attendees. Okay. So Valerie Samuel, she is an expediter. She's a property compliance code and zoning professional. The name of her company is All Borough Expediter. She has 20 years of experience in this Queens-based business. She serves as an advisor regarding any type of development or project management. Valerie has helped MWBEs, that's Minority Women and Business Enterprises, entrepreneurs, and property owners navigate the intersection of these agencies that impose violations upon people's homes. She deals with certification as an MWBE, contracting opportunities, and overall property compliance and expediting. I have personally used her. I have many, many, many clients who have used her, and they all came back violation free. So that is our co-sponsor, All Borough Expediter, Valerie Samuel. And again, I'll present first, and then Valerie Samuel will present right after me. Ms. Samuel, would you like to say hello, though, at this time?
Yes, thank you, thank you, thank you. I appreciate that. And that is true. You have definitely given me an opportunity to show you that we get things done fast and done right. And I'm so thankful to be here today to share whatever I can to give people a heads up on how to stay code compliant. Thank you.
Yes. So many of my clients, when I meet with them as a litigator, as an attorney, real estate attorney, these violations face many homeowners all the time. And they always start off with a notice that sometimes is just ignored. Sometimes they inherit a property that have these violations, or they bought a property with these violations. But either way, it becomes a nightmare because they ignore the violation, it morphs into a fine and then a lien, and then eventually their property is at risk. So we're going to go into how does that happen. Okay, so let me first share my screen. Okay, so we have a few major agencies that hand out these violations. And the ones that we are dealing with today Um, as I list them, will be the New York City Department of Housing Preservation and Development, commonly known as HPD. We also have the New York City Department of Buildings, commonly known as the Department of Buildings. We will also talk about the New York City Environmental Control Board, and that's paired off with oath, which is where you will have those hearings on some of these violations. And then we also have the New York City Department of Health that hands out certain violations, as well as the New York City Department of Transportation. So let's talk about the New York City Department of Housing Preservation and Development, HPD as is commonly known. Now, if you go to the HPD website, and we're going to provide the website to everyone in the chat as this program goes on. But if you go to the HPD website, it sounds like such a beautiful statement on their mission. They're here to provide quality and affordability in the city's housing and diversity and strengthen the city's neighborhoods. And they are here to protect the residents of New York City. So that sounds like such a loving mission. But that mission incorporates code compliance, which is handing out violations to make sure that you are in line with their mission. So, what type of violations does HPD hand out? Well, they hand out housing maintenance code and compliance. So, there's a maintenance code for New York City, and everything is in that law. And from everything from painting every 3 years for tenants, or a 60-watt light bulb in a hallway, everything is regulated by a law. And when a homeowner deviates themselves from that law, then you get a notice or you get a violation. When your tenant may call 311 and have heat and hot water complaints in the winter. Your hot water and your heat's supposed to be at a certain level. And when it falls below that level, or when a tenant believes it has fallen below that level, they can make a complaint. And that could morph into a violation. And then any type of mold or peeling paint, you have lead paint violations. All right, for general living conditions, HPD will hand you a violation and expect you to address that issue. Okay, for the New York City Department of Buildings, they also have their violations, and they kind of focus on construction. So HPD would just focus on the day-to-day living. The buildings department will focus on construction. So if I'm building a skyscraper in New York City, or I own a single family home in Queens, we are subject to the same rules and regulations. And they expect that contractor or that owner to maintain that property within their the DOB code. So if there's any type of illegal construction or alterations, usually a small property owner or 1 or 2 family owner, they'll get those type of violations for an illegal basement. And what makes it illegal is no one gave you permission to put a living space down there. So many people will get an illegal construction like that, or many people may add an extension to their property. All right. But if you do certain things, you have to ask the permission of the Department of Buildings, and then go under the purview or oversight of the Department of Buildings. Any type of alterations like that. If you put a wall where a wall was not, or remove a wall where a wall once was, that's also an illegal construction in the eyes of DOB. Working without a permit. So now I'm doing work, but I got my handyman to do work that he should have filed a permit for. That's working without a permit. And then unsafe structural conditions. That may be maybe bricks falling from the facade, or some type of structural issue going on, and just the overall failure to maintain a building. Those are the violations that the DOB, and unfortunately sometimes it's stacking. So yeah, many people, 1 to 2 family homeowners, we enjoy that open concept with the kitchen. So now we buy a house, or we have an old house that we're maintaining, and we have all these walls in the kitchen, and we want that open concept. So we just think it's very easy just to remove walls, and all of a sudden the next day we have an open concept. Well, number one, that's an illegal construction, right? Illegal alteration. So you'll get a violation for that. And you'll get a violation for you're not supposed to remove walls without a permit. So then that's the second violation, and any other violation that the DOB will see. Then you have the New York City Environmental Control Board. that will issue violations, and those hearings for the DOB and the ECB are heard at oath. That's and they have their own, which I'll put it in the chat. They have their own procedural rules that you are to follow when you have hearings like that. Valerie again will get into addressing those violations, and then I'll come back and tell you certain laws or certain cases that you can use to try to win on some of these cases, and what is the standard for that. And then if you have a lot, a vacant lot, or even a house that may have been abandoned, the New York City Department of Health may get involved if they see or I want to say a mouse, but a rat running through your property. Those violations will be the New York City Department of Health violations. So those are the violations that you possibly can get throughout New York City. Now, what triggers the inspections in the first place? And we're mainly talking about 1 to 2 family homes and maybe up to 4 families. Well, number one, if you have a tenant, that's the major reason why most homeowners, small homeowners, are getting these violations, because a tenant is calling HPD or more than likely 311. It could be something that is warranted, that they see that's going on. Maybe they don't have heat or hot water, and it could be something that's not warranted. But they'll call 311, and that kind of starts the whole interaction with you and these agencies. So what else can trigger it? Well, neighbor complaining. It could be an envious neighbor or someone who actually is looking at your property and they see some type of dangerous situation going on. You see this in Long Island more, but you also have neighbors who constantly are fighting for a parking space, and your tenant that you put in the basement is constantly taking their parking space. So then they call 311 saying they think you have an illegal basement. So that would initiate HPD going to make sure that violation exists or doesn't exist. And then any type of non-compliance with their law or an unsafe condition that is observed by an inspector. Because when you invite that inspector into your house, and we'll get into that access in a minute, but when that inspector is in your house, if he's passing by, if he's on his way to a violation that may exist in the basement, every other violation that he sees while he's on the way to the basement, he's going to give you a new violation for. So if he's entering to your house, going to the first floor, but he looks up like in a 3-family house and he sees the hallway on your 3rd floor, and he sees the tenants' bicycles and all their personal property out in the hallway because they don't have, or they say they don't have enough space in their apartment, and they're using the hallway as storage, that's a violation. So everything that inspector that's already there for something else, everything he sees on his way to that violation site, he can give you a violation for. And then as a owner of a place that's usually being rented out, or a 3-family and up, and even for 1 and 2 family homes, you have certain guidelines that you're supposed to follow, which we will get into a second. Your property should be registered, and I'll tell you the requirements to registering your property with HPD. You're supposed to send in lead-based paint or lead paint disclosures and bed bug disclosures, and you're supposed to have certain signage around, right? So if an inspector, if he's there for some reason and he asks you, I need to inspect your boiler, and you're the owner and he knows you're the owner, and you say, I don't have keys to the boiler, because you don't want him to go down to the basement because you know you have an illegal basement that he hasn't even seen yet. If you say, I don't have keys to the boiler, you'll get a violation for that, because there's a law that says that the city is supposed to always have access when they need it to your boiler. So that's a violation. So that's another way you can get a violation. Another way you can get a violation is they're commenced in HP actions. What is a HP action? HP stands for housing part. So these are lawsuits or proceedings that are initiated mostly by tenants. And that's when they have a complaint and they want the court to get involved. So they try to escalate it a little bit. So they go to housing court, the same court that you would go to evict that tenant. They go to court and they file a complaint saying that they have a lot of things in their apartment that need to be addressed, and the landlord is not addressing it. So that starts an HP action, and at that first court appearance, that judge could order an inspection to take place because a complaint isn't a violation. So the court won't know whether it's a violation or not. So he'll have a court ordered inspection for that. So that's another way you could get an inspection on your house. And then many times you're trying to evict the tenant or you're suing for the rent. And the tenant may say the reason why they're not paying rent is because of the conditions in the place. And if you're denying that and there's a major debate on um, whether something is on whether these conditions do exist, then the court itself can order an inspection on your house. And it's not even HPD, it's actually some court personnel going to the house. So those are the ways that an inspection can be triggered. And Valerie will get much more into this, but for HPD, they kind of separate their violations into three major categories: Class A, Class B, Class C. Class A is something that's not too bad, such as having no light in the hallway. You're supposed to have a 60-watt light in the hallway. That could be a violation. You have 90 days to correct it. Valerie will get into how you correct that. And then you have something that may not be, maybe a little worse than what I just said, but not too bad. And then you have 30 days to correct it. And then you have the severe Class C violations. Those are major violations in the eyes of the city, such as no heat and no hot water. Those violations you probably need to take care of within 24 hours, or it could probably be escalated into fines and emergency repair charges and liens and things like that. And Valerie, again, will get into that. So one of the major questions I always that always come up is from clients would be, do I have to let the inspector in? So that's a question that's maybe it varies with the answer. So of course, if you ask anyone from those agencies, HPD or Department of Buildings, do I have to let you in? They will say emphatically, absolutely. If you ask an attorney whether you have to let them in, we may say you're supposed to let them in. But I always put it back on the client and say, well, what are the consequences if I don't let them in? And then that will probably decide whether I let them in or not. So, what are the consequences if you don't allow the inspector in? Well, it depends on what's going on with your property. Let's talk about that. If you have a HPD, if you have a house and you don't have any HPD violations at all on that house, like pretty much you don't have any, or they're very minor, and you don't let that HPD inspector in, eventually they'll probably close the case. You have to realize that complaints, whether it's coming from a neighbor or a tenant or anything, a complaint is not a violation. And if there is no access and if there's no inspection by an inspector, then there is no violation. You can only have a violation if it was inspected by a HPD inspector or a Department of Buildings inspector in general. Okay, there are exceptions to that. So if you don't have any violations on your house and HPD comes out there and they want to inspect and they say, oh, I think you have an illegal basement, you won't get a violation on that illegal basement if they don't come in. I'll just leave it at that. Now, if you have a Department of Buildings inspector come to your house, again, if you don't have any violations from the Department of Buildings and that inspector says, I'm here to do an inspection of your house, again, no access, no violation. And I'll leave it at that. However, the caveat is, because I don't want, a lot of emails saying, oh, I didn't let them in and now I got all these violations. Well, because you probably had a violation and they were probably there to see if you corrected an old violation. So if they're there to, especially Department of Buildings, if they're there to inspect to see if you corrected an old violation and they don't get access, you'll get a violation for not correcting the violation because there's an assumption you didn't correct it because they didn't see a correction. So again, I would say speak to a professional. But the general rule that you could defer to is if I don't really have violations against my house and they don't have access, they can't give me a violation in general. But you won't get a violation at that moment. There are maybe down the line, there are other ways that they could escalate this. So let's just talk about escalating it. But remember, no access, no violation. Just keep that in mind. Um, Now, if you did get remember, if you don't have access and the tenant is constantly complaining about your property and you're not giving access, you're not giving access, eventually those violation inspections will be closed out. But the tenant, remember, can escalate this. They can take you to housing court and start a HP action and tell the judge, tell the court, I have all these complaints. The landlord's not permitting HPD giving them access at all. So I would like an inspection order. Now, once the court orders an inspection, you have to let them in because you will be held in contempt if you keep refusing access in the face of an order that directs HPD to have access to your property. I think it was 2 weeks ago that they showcased a big landlord, I think in the Bronx, who was arrested and served a little bit of time in jail for failing to provide access to HPD. So if there's a court order, definitely let them in without question. Also, if there's a partial vacate order, now how does that partial vacate order comes? Well, at some point in time, they may believe that there is someone in the basement. They maybe they have inspected that there's someone in the basement, and now there's a partial vacate order from the Department of Buildings saying that everyone in that illegal space, usually a basement, it could be an attic, but everyone in that illegal space has to leave within 48 hours or something, or 72 hours. And it's a very short period of time. And that's because they probably already have some type of knowledge that there aren't, that is very unsafe, such as there is only one way of ingress or egress. So if you have a partial vacate order, and they're coming in because they're coming in with the authority to break the door down. And in those cases, if they do find someone still in possession of that property, um, the Department of Buildings, they come with the Red Cross. They'll remove whatever tenant or whoever's living in that basement. They'll personally remove them, such as a tenant. And then they put that tenant, and if that tenant says, I have nowhere to go, then they'll put that tenant in a hotel paid 100% by the homeowner who created that illegal situation anyway. And if it takes a year, and remember, many times it does because the hotels are nice. If it takes a year for that tenant to find a new place, then that bill is on you, and it's called a relocation lien. And the city of New York would squarely put that lien on your property, and you'll have to pay it if it's ever sold. So with a partial vacate order or any type of court order, 100% give them access. Let's talk about if you have a violation, but you're ignoring it, right? What's the consequence of just ignoring a violation? If you have a violation and you're ignoring it, it could just sit there forever if it's not really a big deal. But if it is one of those heat and hot water or a B or C violations, all most C's and sometimes B violations, then and the tenant is constantly still complaining, then the city of New York could hire a contractor to do what you're not doing, which is to fix whatever problem that exists because of that violation. And when that contractor who is hired by the city, when they come and repair something, it's not at the handyman's price. It's usually 10 times that amount. And the city blindly pays the bill because they figure the homeowner is going to eventually pay this because they'll put it back on your property, and it's called an emergency repair lien. And then you don't pay the lien, you get notice to pay the lien, you don't pay the lien, it's transferred to the tax department, you don't pay your taxes because now it's part of your tax, you will end up in foreclosure on that property. Okay. What happens if you continue to ignore many violations? When I say many, I'm like over 100. And it's not too difficult to get over 100 violations. for HPD. So if you continue to ignore these violations and they continue to build up, then HPD can do what's called appoint a 7A administrator to your property. And that's the highest form of escalation, in my opinion, that they can do, because now that basically your property went into receivership. Essentially, they have appointed someone to collect the rent from the tenants and use that rent to make repairs. And you no longer have any type of role at all in your own property, whether it's a three-family house or I mean, I've seen them do it to something as small as a three-family. And they appoint this 7A administrator to basically take care of the violations, but they have so much more control than that. And even when all the violations are taken care of, that 7A administrator does not step away. It's you have to actually present a case for you to take your own property back over. Number one, you have to get insurance for the building, which will be difficult because you have a 7A administrator and some violations. You also will have to produce contracts or proposals or estimates from only licensed at this point, licensed contractors and all the trades, the plumbers and electricians, all of them at realistic prices. So it can't be a cousin who's saying that he'll renovate the whole house for, $2,000. At realistic prices, you have to show that you are hiring these licensed contractors and trades. And then you have to show bank statements that show
Bring
that,
every time you do something, you got something that I did, you made up.
Aaron. And then you have these contractors, and then then you have these bank statements that has to show that you have the money to actually pay these contractors um, to do the work. And these bank statements also have to show that you have the money in the bank to continue to care for your property as you should. All of this has to be done before they give you your building back. So that's the highest form of escalation they can do. We already talked about the the HP action that's filed against the owner. So if you continue to ignore these violations, and the tenant could file an HP action, that's a court action that's against you, and they also sue HPD. But when you get that case and you see that the tenant is suing you and HPD, and it looks like HPD is a respondent on the same side of the lawsuit as you, please don't think for 1 second that you and the HPD are in this together. They are not your friend, and they actually will be silent and working with the tenant to make sure that these violations get done. But if you don't do the violations, or even if the court finds that at that point that these violations exist for a certain amount of time, at that point you could be fined a certain amount per day just because of these violations, such as heat and hot water. I think it's like $500 a day. Some of them are $1,000 a day. Typically, other than the emergency repair liens that could come when the contractor does work, or these HP actions, and that's court, that's not HPD on its own. HPD violations do not come with fines or monetary penalties at all. It's just a violation that is filed against your house that can morph into these things. However, I have next, these violations could be rent impairing violations. So now you have a set of violations against your house. You sue a tenant for rent, for back rent. This tenant could bring up the fact that I'm not paying rent because of the violations. Now, we know that's generally ridiculous that you're not paying any rent at all because of some violations. So the court will not give them 100% abatement and say you should live for free, but the court will look at the violations to see if they're rent impairing violations, and could reduce that tenant's rent per month while he was living under those conditions, generally like a third. So if he was paying $1,500, then the months that we're suing for, that the judge sees these violations, it will he owes $1,000 until these violations are done. So even though HPD violations in and of itself do not carry fines and penalties with them, they could still hurt us in our pockets. Okay. And again, if you do have some of these violations and they're not a big deal, they just don't drop off just like that ever. You will have to, and Valerie will get into that, you will have to do something to remove these violations from your property, no matter how old. I've seen violations back from the 80s. on people's properties. Okay, let's get into HPD and property registration. I'll put this link in the chat. I get into this with a lot of clients about registering your property. Now, in New York City, in the 5 boroughs, there's a law that says that any building that has 3 or more apartments in it, it must be registered. So let's talk about whether you have to register or not. Any building, if you're an owner of a building that has 3 or more apartments, you have to register. If you're an owner of a 1 or 2 family house and you don't live there, you have to register it. So the only building that won't be registered and you don't have to register is a 1 or 2 family house that you live in. And just think, either a 1 or 2 family house that I personally live in, or everything else I own in New York City has to be registered. It's as simple as that. Well, many times, and we could check out registrations online, but many times these houses or these properties that you own may not be registered. You may live in Long Island, you may live in New York, but you have other properties that you rent out and they're not registered. What is the downside of not registering your property? Well, we're talking about violations today, and we're talking about fighting violations. And one way you can fight violations is by saying, I wasn't served properly. I didn't know about the violation because you sent it to an address that I don't even live at. Or you served a summons, if it's the Department of Buildings, you served a summons on me and I don't even live there. First thing they'll do is they'll go to the property registration and see what that says. Oh, you don't have one. Okay, so we can send it anywhere we want because you never told us where's the proper place for you to receive this information. Okay. Also know not registering your property is a violation in and of itself. So let's say you have a real clean property and it's you don't live in a property. It's either a 3-family or over, or it's a 1 or 2 family home and you don't live there. If you go to the violation, the website, HPD's website, on the violation page, it may have 5 or 6 violations and they all say failure to register your property. And those violations are violations. And each one of those violations are $13 because it costs $13 a year to register your property. So, and they don't go anywhere until you finally do. Lastly, failure to register your property will prohibit you from collecting rent from that tenant if you sue them in landlord-tenant court. So all properties have to be registered. In fact, on their website and on the property registration, it says if you don't register, you cannot collect rent from your tenant. People collect rent anyway. I mean, that's great. Nobody knows. However, now the tenant stopped paying me and I sue them in landlord-tenant court on a non-payment. Part of your court papers have to say whether your property is registered. And if your property is not registered and you can't work something out and try to settle, unbeknownst to anyone, that your property is not registered, if it gets before the judge and they see that it's not registered, your case will get dismissed because you do not have a right to collect rent for a property that is not registered under that first paragraph that I just talked about. All right, so how are we going to protect ourselves? Because there's a lot of stuff, and we didn't even get to the meat of it because Valerie has to talk about what are we going to do with all these violations. So how do we protect ourselves? Well, it's a paper trail because these are court proceedings, right? So it starts off with maybe a tenant saying, I need work done in my place. So now you raised my eyebrows. I need to start saving this because this can morph into something big. So you save that. First thing you do to that tenant, if you care to, is you ask them, when can I have access? And many tenants might not give you access. But if they do give you access, they may not be home. So now I'm going to document that. I have my contractor with me. He's going to sign a piece of paper that says he was there. You have to keep a paper trail. You have to keep contracts, even your handyman. Tell them write something on a piece of paper, like an invoice, and mark it paid. Because you have to keep a documentation of all of this. Because remember, in court, unfortunately, it's not about what is the truth, it's about what you can prove. So keeping this correspondence, text messages, and all these things will be very important. And then when you do the work, when you finally do the work, or people are complaining about something, you will document everything with photos. You're going to take a before photo and an after photo, because remember, you just have to comply with that violation, but sometimes it's not done to a tenant's taste. So that photo, that before and after photo, would show probably what I got the violation for, and the fact that it was completed. So now I don't need the tenant to testify on my behalf. I was able to take photos, and that will work. So you have to keep everything in a folder and keep all these things, because at some later time you will probably use it if you're going to challenge these violations. And you also keep a lease, because I'm not in favor of leases at all in New York City. I'll just put that out there. But you can have a month to month lease. So I'm not in favor of a year lease or 2 year lease. And I know if you use a lot of these programs like Section 8 or FEPS, you have to have leases. But even if you don't have a lease, I would have a month to month lease. And somewhere in that lease, I would say that you have to let me in to make certain repairs on your property. And that's a substantial violation of the lease. Okay, because then that may be a way that will not only help me on these violations, but also expedite a tenant's exit from my property. Okay. So I'm going to put up this resource and assistance list after Valerie speaks. But that's what I have on the overview of the agencies and the violations, especially as it pertains to, let me stop sharing, as it pertains to HPD. And Valerie will use her esteemed knowledge and esteemed experience in dealing with the Department of Buildings, and just how we address and try to resolve some of these violations. And again, I'm going to come back later and give you a case and what you can talk about of how you can try to present your case to DOB as a defense. Thank you. Valerie Samuel.
Thank you. Thank you. Should we put a poll in while I start my presentation? Question. Let's see here.
Sure. And we're going to put certain questions in the poll, certain questions in the chat. And we will hope that you answer it. This way we know how to address your specific concern. Also, I'm going to put an email for the Du Bois Bunch Center in the chat. If you email your name and property address to us, between Valerie and me, we will search your property for HPD violations as well as the DOB site and send you back a report on your house. And then if you want to make an appointment with us to discuss it, you can. Thank you.
Okay, thank you, Attorney Dudley. So again, I'm Valerie Samuel, and I work as a licensed expediter with the New York City Department of Buildings. So I see a lot of different situations every day. And over the years, I've had a whole lot of them that I can tell you. And ultimately, I'll just share a little bit about my knowledge on how I feel about these violations. But ultimately, we'll just talk a little bit in general about a homeowner's guide to navigating these systems. So, when you become a landlord, mainly in New York City, it's a tough place. And a lot of checks and balances have to go into it. I remember times when I just would like, okay, I have a tenant, you know what, here's a standard lease. I would go to the stationery store. But no, leases have to be very specific these days because, as Attorney Dudley was explaining, as a landlord, you have to really protect yourself, mainly with a lot of the programs out here now with the city agencies educating, not only homeowners, but also the residents of these homeowners who have, let's say, two family and up. And that's a situation that can cause a lot of issues, mainly when it comes to paying your mortgage if you're not free and clear on your property. So I'm going to talk a little bit about that. Looking forward to your questions. Let me know if you have any concerns at the end. Let me reduce this here over here. So there's, again, several different agencies. There's more, but we're talking specifically about Department of Buildings, Housing Preservation and Development, the Office of Trial and Hearings, and Department of Health and Mental Hygiene. In terms of the Department of Buildings, here's what I would say. Department of Buildings is very specific, and they do carry fines with most of their violations. They do have inspectors. When the inspectors come out, many of them carry, firearms. So, and it can be intimidating because they are police, they're building police. And they may, intimidate some and they let them in, or they may intimidate a tenant and they let them in, but they are persistent. And they do give complaints when they can't get access, but a lot of times, they'll just keep coming in, and sometimes they'll eventually figure it out. I had a situation in Queens 3 weeks ago where they purchased the property years ago, and they got the violation several years later when all the systems started merging, because Housing Preservation and Development, Department of Mental Hygiene, oath and hearings, like, and DOB, everybody talks to each other now, including Con Ed and all of these utility people. So everybody has eyes and ears on your property, and looking to report, some code or zoning violation. So that you should definitely keep in mind. I know that's a lot right there, but it's really true. Everybody is looking to say, well, the electric is not right or this is not right. But going back to my story, they called me in. I went to visit them and found out that, it was a mom who purchased a house with her husband years ago. She wants to get ready to leave it to her two older, children. Well, they're not even children, they're grown people. But they found out that they had these violations because they came in the mail when they started refinancing, as Attorney Dudley mentioned. And they were like, no, 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 I can't do this. They went through all the programs trying to figure out, well, no, I didn't do the point is the violations carry, or the violations follow the property, not the owner. So when you go into a situation and you don't have a clear title, the DOB will eventually, find out, or HPD. Somehow these people find out exactly what's going on. So I would say, in terms of Department of Buildings, if you need something and it seems like it's structural, call a trade to see exactly what you can do to find out how you need to do it properly. And I will also say that Department of Building contractors are licensed, and when I say they also have tracking numbers, that means that they have their insurances, liability, disability, and workers' comp parked with the Department of Buildings, and that means that they can do certain things to the property, and you can get what they call a work permit. So it's very important to follow the protocol that a Department of Buildings would have. And they do have all kinds of violations that they can give you, from the facade to a garage that you built, or to, a basement apartment, all kinds of violations that they can cite you for. So that's important. Housing Preservation and Development, that's another agency. They're tough cookies. They're tough cookies. And they've gotten even sterner with some of the things that they're doing now and how they operate. I will tell you that all the different ones, they're pretty much all the same in all the boroughs, but some are more lenient than others. And others are, they change the rules on a regular basis. So your tenants can definitely report you. I have a situation now with uh, a company. Well, they're investors, and they have several different properties in the city, and their tenants just continually keep reporting them. They're trying to get things resolved. They have a bill of over $100,000. We've tried to get the violations. I've even tried to get them waivers, but with the tenants not given access and continually, just giving them a tough time, it's very hard for them to do anything that they really want to do. It's frustrating. They're actually stressed out. So it's very important, as Attorney Dudley said, to keep your property registered. And I want to say why. Why it has to be registered is it's a safety issue, first and foremost. If something happens, they need to know who to contact in case of emergency. If the fire department has to get in there, police have to get in there, whatever could happen, you want to know who you can call. I have another client that's in California. We went to register their property. This is a new rule. 2 years ago, we got him registered and he was fine. But the problem was, this year they decided, you know what, you can't have a out of state address and expect for us to mail to you. You have to have an address that's here in the city for us to actually decide, for us to actually register you. So it was rejected the first time, and I didn't understand why. But when I further started digging, that's what they told me. No, now you have to actually have an address and a phone number in the city of New York, or they will reject you. So it's about safety. They want to make sure that they can contact somebody that can, boogie over to the property and do what they need to do. Now, the Office of Administrative Trials and Hearings, that's a whole nother situation. That's like the legal arm of the Department of Buildings. They require you to actually come to that hearing, or you're going to default. If you don't want to default, you need to at least communicate. Communication is key. I will say that with all of these agencies, but with trials and hearings, if you miss that first hearing because you picked up a work without permit, or you picked up some type of ECBO violation, that is going to give you an opportunity to get it reopened within like 75 days. But you have to know that to actually know that, to actually request that. If you don't, you automatically default, you automatically pay the bill. But even more so with the Department of Trials and Hearings, you still are in a situation where you should have done some work. They give you normally 30 to 45 days from the time of the actual violation to get things in order. So I would not go personally to an actual trial or to a actual hearing without saying I've done X, Y, and Z. It's a different story if you want to argue you didn't do it, and plead your case. But if you know that you're guilty and you needed to, and you haven't cured the property, then, push it back and try to get a new date, but try to do something, because otherwise that bill is just going to continue to climb. These people are really serious about safety in the city. I mean, you've seen the news. There's a lot of different buildings that are going on, from parking lots that are falling down because people are not, code compliant. They're taking shortcuts. There are no shortcuts with this, mainly when it comes to some of these buildings and your health, your neighbor's health. And neighbors do report. They call all the time and complain. So that's really important. In terms of the Department of Health and Mental Hygiene, I have a club in the city that's been around since, like, for another 120 years. And we had to get some permits and all of those kinds of things for them, but they picked up violations because they weren't in a situation where they were compliant. They did have a couple of those rodents and things of that nature, but they also had to renew their permits. So it's also important to get your inspections and to stay compliant with things that are required, because you are working with the public. And that's really, it's really important. It's hard being a landlord if you're not adjusting to all the different criteria. I would get myself a calendar and I would put on what's required, make a checklist, and know exactly what's due with when, whether you're a sole, a one family, or two family, or three family. I would definitely understand what my requirements are and try to comply with those things on, and all the new rules. There's a lot of new local laws as well that's coming out. Let me move on to the next page. Again, some of the triggers outside of what Attorney Dudley said are these neighborhood complaints. These people, for whatever reason, they just want to tell on you, or they don't like what you're doing, or they don't like the fact that you are, upgrading your house, making them want to upgrade their house. I know you've heard the term keeping up with the Joneses. So or they just don't like you for whatever reason, but they do call on a regular basis. And I will tell you this, there's not enough inspectors in the city to know all of this stuff and to be able to be in all of these places and to issue all of these violations. Someone is calling because they feel like it's an unsafe condition, or they just don't want to, they don't have anything else to do. So it's your responsibility to know your rights, know what it is that you need to do, make sure that you do what you need to do, and make sure that you do it safely. There is a difference between a home improvement contractor and a licensed contractor with the DOB. A lot of times people say, "Oh, I can get myself a contractor," and they do. They go and get someone. They build a deck on the house. Well, the neighbor called. You got a violation. If it's a work without permit, it's coming under the Department of Buildings. You've got to get yourself you got to pay a lot of civil penalties, a lot of fines, but more importantly, you got to get an architect, because that's the type of violation, a work without permit. Anytime you see work without permit, you need an architect. That's just the bottom line. So automatically, no, that's a few thousand. So if it's to your advantage to know exactly what you're doing, or to vet, call the school, call the team that's available to you to make sure that you're getting the help that you actually need and that is the proper help, because any old contractor is just not good enough. They have to be licensed. And when I say licensed, I mean have a tracking number with the Department of Buildings, because a lot of them are licensed, but they don't have the tracking number with the Department of Building, and they cannot post a work permit. And work permits on your property tell the world, tell the neighborhood, tell your neighbors, hey, I'm doing it correctly, I'm doing it safely. And those work permits have to be posted 72 hours prior to any work starting. So if they see a big dumpster in your backyard, but yet they don't see a permit on your front door or on your window, that's a reason. You're giving the neighbor a reason to complain. You're triggering them, and they're in a position where they are, probably going to call and tell it, depending on, how much they like you or how little they like you. It really depends. So be responsible in terms of knowing what you need to do and who you need to do it with, so that you can accomplish without all of the excess, problems and stress that come with this. Because when the Department of Buildings or HPD, when they come to you with violations, you got to pay. You can't go to the HPD without, spending, if it's a one family house, $250. If it's a two family house, well, one family, two families, $250. Three family, it's $300. So you have to pay to have them come out and inspect your property so that you can get something dismissed. And as Attorney Dudley just said, when they come out, they're looking at everything. So if the light bulb is too bright and they feel like, it's the wrong light bulb, or you don't have the carbon monoxide latest, system in your bedroom as well as around the house, then there you go. There's another violation, and guess what? You've got to pay that 250 or that 300 again. So it can become costly to actually cure these violations. So that's why I say being responsible in advance will be very helpful to keep you code compliant. Again, there are different types of violations, and I'll just reiterate some of these that Attorney Dudley just talked about. The C violations, I will tell you this, the C violations, I'm going to start with those because I have 5 different groups that I'm working with right now who have lost their insurance because they have C violations. That's no joke. If you have holes in your floor, holes in walls, rats and mice coming around, lead and mold, heat, hot water, broken stoves, things that are just considered C violations, they are considering that immediately hazardous. If you're not getting those things fixed and paying for an inspector to come in right away, so you can get that cleared, you're in a bad situation. Because what's the insurance company? As I said before, all of these groups are talking to each other now. I started picking that up about 2 years ago. I didn't know when they started calling me and saying, "Well, I got a C violation. I need to do X, Y, and Z. I need to get it done fast." Well, you can get these things done fast, but you also have to have a budget to get a lot of this stuff done. It doesn't come, cheaply. You have to pay to get some of these things done. Lead violations in themselves is going to run you, in most cases, at least $1,000 to get a lab to come out and take a peek at what you're doing. Even the mold, that costs money. You have to get these agencies to come out and do the testing and then put the reports together. And so these things are costly. So it's really important to just understand that you have to you have to know what you need to do so that you don't get caught out there. Because if you don't have the budget to take care and cure these things, that becomes even more problem. And no one wants to lose their insurance. I have 5 groups right now, different groups that are operating without insurance on their properties, and that's not good. And if you do get the insurance from somewhere, State Farm or whomever might want to give you some insurance, trust me, it's not, most of the time it's 2 to 3 times more, right? So that's really that's a dent into the pocket. Now the B violations are hazardous as well, but that's dealing with the leaks and inadequate lighting. You might say inadequate lighting, yeah, well they have standards on what they want the lights to illuminate at. So that's important. Water coming from the ceiling, unlawful bars on your windows, Again, missing smoke detectors. Of course, everybody needs to have a smoke detector in their house, but if you have these things and these things are missing, that's a problem. I will also tell you now, I was with someone today, and they're also like on your doors, they're also requiring you to have certain type of signage on your doors. If you have a three-family house, a certain type of signage that has to go on the doors, and you have to make sure that you have that, because that right there, if they have to come out, the inspectors, that will get you another violation. So it's really important to know what the rules are for the type of property that you are maintaining and that you're living in. And of course, the non-hazardous things are, like not having a number on your front door, so that if something were to happen regarding code and zoning and the fire truck had to come out, how would they know your address? They shouldn't have to be hunting down and figuring out if is that the door or is that the door. That's very important. Even an improper seat for the toilet can get you a violation. Again, when they come in, and of course this is HPD, when they come in and they see these kinds of things, they can cite you. So you really want to make sure that you know these things. You can go into the HPD site and look at some of these things now and see what they do and what they want and what they expect. So this way you can have your property up to code should someone decide to call neighbor, tenant, or if they need to come over for whatever reason, you're in good shape. Enforcement. Here is the process. So the violation is issued. It comes in they come out, they take a sneak peek. Sometimes they can't get in, but if you have windows, they might be able to peek in. So maybe they didn't get access, but I do have a situation where the house is big, it's a one family, but they could not get in, but they were able to look in the window. They saw all the partitions, they saw the bathroom, they saw everything in the basement. And guess what? They got it. So the group is arguing, no, no, no. They never came in. I didn't get access. Yeah, well, you had a window. And the windows, in fact, they had a few windows. So they were able to actually see that you were not in compliant and you had an illegal basement. We call illegal basements a 45. That's what the industry knows them as, and that's what we call them. So when if you have one and you would want to try to see if you can get it legalized. Now, if you do get it legalized, you should know that that's changing the use of your property, which is a whole nother story. The second step is once you get the actual violation, after they've taken a peek and seen inside that you have partitions, so you have a basement bathroom, the whole bit, the three piece, then they send out the notice of violation. It's normally yellow. Okay, and that's coming from the Department of Building side. It's normally yellow. And then you have to go to the oath. We just talked about the oath, the hearing. That's where you go and let them know, look, I've started the work. Maybe you haven't done everything because it takes a while, mainly if it's a work without permit. You haven't done everything, but you've done a lot of stuff and you've got some things in place. That's when you go as the respondent and you appear and you talk to them about what you have done and you ask for a little bit more time, and they will give you a little bit more time, but you do have to come back and prove what else you've been doing. You're still going to have to pay. You probably won't have to pay the whole fine, but you will still have to pay because again, you were doing something that was against against code and zoning. So there is going to be a fee, but it just may not be the full fee, and it may not keep going up. Now, I do have someone that picked up a fee. They missed the hearing and they got it reopened, but they never paid the fee after it was reopened. And the fee went from 2,500 to 5,000. So, it can pop and it can grow and interest is accruing. So that's something to think about. Again, know your rights, know what needs to be done, put yourself a calendar together, know what you need to do, know about the local laws. It's not really, that easy to be a landlord these days because it almost requires being a property manager. You really are a property manager. And if you haven't, you know, taken a course in property management, if it's a two family that you're into or you're an investor, however that is, you might want to consider doing something like that. Now, after the hearing, the decision is made. The court will have in that meeting If it's DOB and fire department or HPD, whoever is involved with the citation, with the violation, those people will appear at the hearing along with you. If you have your attorney that's coming with you, that's fine. If not, you can do it alone. It's up to you how you want to be represented. And at that particular time, based on how far you are into the process, they will actually be in a position to tell you what they're going to do. Are they going to cut the fee? They're not going to cut the fee. If they're going to dismiss it, depends on the case and how you're presenting it. And 5 possible outcomes, as I just said: the dismissal, the violation, et cetera, and whatever the penalty is. Normally, the penalty you don't pay at on the spot. They send you out a decision, and you probably get it within 30 to 45 days. And then at that point, you're in a position where you have to pay that fine at that time. Okay. When violations turn, when violations, when violations turn to liens, oftentimes I get a lot of calls from attorneys and title companies because when people are refinancing and when people are selling, doing quick deeds or buying, these things come up. A lot of times it comes up, towards the latter part of the deal. And, people have to really start scrambling to mainly, depending on their budget, they have to start scrambling to see what they're going to do. Now, if you're selling the property, most times you're going to be asked to cure that property and cure that violation. If you're buying the property, you're going to want the seller to do it. But, if you're an investor, then you're going to want to just decide on what you're going to do. But they can become liens on a regular basis. The only thing that I know that doesn't become a lien is the elevator fines and the boiler fines out of the Department of Buildings. Everything else it carries interest and can become a lien on the property. Although they will show up, I believe, on your title, but they don't actually become liens. But those other items, they definitely can become a lien on your property, and you will be blocked from actually, doing anything in terms of refinancing or selling or registering, and even in some cases. So you do have to make sure again that you monitor and know what exactly is happening with your property to avoid any liens. I mean, that's the last thing you want to do is go to the table and try to refinance because you want to rehab your property or do some upgrades, do an extension, and then you get there and because to get money, and then you get there and you find out you got to spend some money before you could even get started. So make sure that you know in advance what's going on with the property to avoid any penalties that you may have and to not get any judgments. I mean, it's the last thing you want to do is have a lien on your property or on your credit report for something that you didn't even know was there. So it's very important to stay on top of what's going on with your properties. Clearing and protecting your property. Yes. The certificate of correction is something that the Department of Building likes to do, and that is expected for you to get and that's a process in itself. It's not just you submit 2 forms, the AEU and the AEU2. Then you have to put photos together. I mean, you got to label these things, and you have to prove that you've used licensed people, depending on what it is. It is a facade, whatever it is. So that's on the DOB side. On the HPD side, it's a little bit different. You have to put a dismissal request in, and you have to pay for them to actually come out and do the inspection. But either way, that is a process that has to be done, and there's paperwork involved, there's photos involved in the DOB case that you have to, comply with. And it has to be done correctly. And it takes about 30 days, about a good 30 days for them to look at what's there, make sure that what you're telling them in your correction is what they're telling you to do for the cure. So the language has to be very precise. It's not like you can just say, well, I just fixed this. There's a format that has to be followed, and you have to actually know that. Otherwise, you just keep doing it, and keep doing it. And it's never guaranteed that you're going to do it, but that you're going to get it right the first time. But you do have to follow the format that they want to see to make sure that you can get that release from your profile. The last thing you want to have is a profile that has, all kinds of outstanding violations that's causing you penalties or failure to comply. We call those FTCs, failure to comply, because that shows that whether you are or you're not, it just shows that, you're a poor property manager, and you don't want to be looked at that, mainly if you got to pay a penalty and you got to go before hearing, because they'll say, well, you really don't care anyway, so you're not really taking care of being responsible for the property. So thus, you know what, we're going to charge you the max because we want to teach you a lesson. That's pretty much how it goes, right? Now, in terms of the dismissal, again, as I said, these dismissals can take up to 30 to 45 days on the DOB side. With the HPD side, they may not take as long, but you do have to wait for the inspection. And the inspection, we had some holdups and some hiccups this winter because of the snowstorms. So things got a little bit behind. But for most of the different boroughs, they're coming back online, and everybody it's taking maybe 2 to 3 weeks. So the long-term impact of unresolved violation, as I said before, selling your property could be a major obstacle because you can't do it with a violation technically. Refinancing the property is going to be a problem because the lien is going to pop up. And if you're doing any type of transfer and estate planning, they want to see these things cleared out before. They want you to have a clean, smooth property, um, that you're transferring over without any issues. And I would think that most of us as homeowners would want the same thing. So some key takeaways: when you get that violation, act quickly. Correct the violation first, then handle the fines to stop the penalties from occurring. You you do not want to pay more than you have to pay. And again, some fines you can see right there. Well, the fines you can see right on the profile, but there is something called a civil penalty. And a lot of times that civil penalty you cannot see. That has to be requested from the fee estimator in the DOB case. In HPD case, you may have some fees that could pile up from emergency repairs, but you'll find that out also when you go to register. Outside of that $13 fee too for the registration, they will let you know if you owe any money. It'll come up. You'll probably find it on your property tax bill. And if there's some tax, they're going to look at all of that before they register you. So they're going to make sure that you have a clean slate before they even let you get registered. So get some proof. Always obtain a certified correction and an official DOB, and you should have a folder for your property. Like you have a folder for other important papers, you should have a folder for your property records. In fact, I tell people they should know everything about the property, whether they bought it new as a new build or from before. I would want all of my records that are available to me on the property, applications, reels, anything that's available, so I can know the history of the property, like a car. Like with cars, they have Carfax and other kinds of things to keep a track of everything about that car. Well, with your house, you should want to have that too. And for as far as the documentation goes, file it in the cloud, file it in wherever you need to file it, have it in a couple of different places, because you do not want to be in a situation where you can't get access to your important documents. Normally insurance companies give you some kind of folder where you can keep a track of this kind of thing, but that is something you should definitely keep a couple of copies of. Well, now we're at the stage where we can talk about Q&A, Attorney Dudley. I'll turn it back over to you. Thank you all for listening. I hope we've helped a little bit.
Thank you, Valerie, for that.
Thank you.
Okay, and I just want to circle back on a couple of the violations. For DOB, you have work without a permit, and you may have an illegal alteration, which are sometimes they're morphed into one. People confuse them, but there are two different things. One is just the existence of the work in and of itself is a violation. Just the fact that it exists is a violation, and then the fact that you did the work without filing for a permit. So many people say, I bought the house like that, or I inherited the house through a will or a trust or something, and the house is like that. DOB does not give pre-existing conditions for um, the work existing in and of itself, because it makes sense. The work is still existing. So if you didn't resolve that violation by fixing it back to its original use, that violation, just the existence that that work is continuing to exist, is a violation. But working without a permit, they're charging you also with working without a permit. Now, if you didn't, if the work is done but no one filed a permit, but you inherited the work like that, it's possible for that type of violation, you can use a defense of pre-existing condition. So I'm going to put in the chat now. I'm actually going to share my screen first. 1 second. And I see your hand raised, Sean Alexander. We're going to get to you. One second, okay?
Okay.
1 second. All right. So you have this this first case. It's called where is it? If you look at the bottom, it's called New York City versus Shangu Shen. I'm going to put the exact case in, because if you dare to do these violations yourself, and we understand that many people, for whatever reason, they're going to handle these violations themselves, right? So we're trying to address that too. I'm trying to arm you with some of the defenses that you can use, especially for work without a permit. And the premier case on that would be the New York City versus Shanghai Shen. I'm going to put the exact copy of that case in the chat so you could just print it out. But let's look at the conditions, right? So a person violated code section is the highlighted part. Section 28105.1, which is working without a permit. So you would have to prove, remember in court, most of the time it's not what the truth is, it's what you can prove. You have to prove to a certain standard that that work did exist, that the condition did exist before you own the house. Many, and remember, many of these decisions can be appealed. So many of the officers, the hearing officers, will sometimes deny you because you're saying that the work existed before I bought the house, and you're just saying that some friends told me. You have to do a little bit more than that. You have to prove it through affidavits. It would be great if some of these old neighbors, right? So if I'm youngish, let's say I'm 30 years old, I just bought a house, but the entire block consists of much older people. So they were there when the house, way before I bought the house. They were there probably with the owner before me. And maybe they came to visit that owner for birthday parties and celebrations and things like that. So they were in that basement that has that shower. You're not supposed to have a shower downstairs. So they had that shower in their basement. Maybe they will come to court and testify with me. And if they don't, then maybe you can have someone write an affidavit. Affidavit is something that's sworn, notarized, that they prepare to the detail, and they talk about when they visited the premises, the year and the dates, and how was it that they came to visit the premises. When you purchased your house, maybe, or if it was inherited, maybe there's an inspection report that shows that where that your own home inspector is detailing the way that condition existed back then, which means that it existed when you bought the house. Your appraiser may go there and take pictures because you're trying to get a loan. But in those pictures, you may see some of these pre-existing conditions, such as an open concept of a kitchen. I bought the house like that. Even the appraiser that I got when I was in contract, even before I bought the house, shows that there's an open kitchen. You can use surveys for like an illegal extension that may be on your house. You may be able to use old surveys that show that that survey is drawn with that extension there. So there are many ways you can try to show that there's a pre-existing condition defense. Again, you have to prove it. And if you prove it, you should be successful on that work without a permit. So I'll put this case in the chat and the language in the chat for your standard. And we have Letitia Walker. You can ask your question. If if Aaron could take you off mute first.
Sorry, is it me or we have someone else?
Oh, I'm sorry. I say LaShawn. I'm sorry, LaShawn.
I was like, I thought my colleague was here.
Screw that up. Sorry. LaShawn Alexander. Go ahead.
Thank you. This has been a very refreshing conversation because I was actually thinking of looking to purchase, property where I would have a tenant and then, be, either upstairs or downstairs or basement. And so this was really refreshing. And so my question is, once you have, because I know she mentioned earlier that, when they sell you the house, all violations should be addressed. So you don't get any violations when you purchase. So that was positive for me. But then when you mentioned that there may be issues in the house still, that, could have not made it through that issue. So it's an important part for you to actually take pictures of the house when you buy it. So that's like a first thing to do. So I actually think that is really helpful. And, the idea of being a good neighbor, is helpful to your tenants so that they know that you live in that apartment or house as well, so that you can address any issues that they have. And knowing that you will be there too, so that, if there's any hot water issues, of course, you're going to be feeling the need for heat as well. So I thank you for this. And, this was really helpful to learn about all these different types of violations that you can get owning a home.
You're very welcome, and all the best to you on your home ownership journey.
Thank you. I'm kind of thinking now just to be a single occupant.
No. Go
Save
for it.
myself the stress of being a property owner.
Every year, buy a building.
I'll buy a building now, right?
Yeah. Well, yeah. Every year, own something. But all the best to you.
Thank you.
And we're here for you as a resource. So I am going to put, I put up the information in the chat. I'm going to share the resources that you can go to. And then I would ask that you peruse the websites of all of the ones, just so to familiarize yourself with these agencies.
Thank you so
and
much.
also, I just want to say that the Department of Buildings and HPD and other agencies as well, but those two agencies, they specifically have what's called outreach events in every single borough. And I also put that in the chat, but you can visit their website as well. But they have these outreach events where they're also bringing their DOB specialists, so to tell you about their violations that they give out and how you can and try to assist you in addressing it. Again, it's coming, of course, from their perspective, but they are very helpful in the information that they give. So I would also try to attend one of those. It's always in every borough, and that they circulate throughout the months of the year.
Thank you so much.
Does anyone else have any questions? Or would you like to tell us about your violation or situation that you have? Let me share this case while we're at it. 1 second. Okay, the one that says New York City versus Shangyi Yu Shin, that's the premier case that you should constantly bring up when you're bringing up pre-existing injuries, pre-existing conditions as it pertains to work without a permit. And the standard for pre-existing conditions, one of the judges, the hearing officers, they actually set forth the standard. Now, in that case, the homeowner did lose, but before he lost, the judge laid it out for what he should have done. So that's always helpful in cases like that.
Very good.
Okay, does anyone else have any other questions or anything? I think I saw, I don't know if she's, yeah, Laurie Miller from Neighborhood Housing Services of Jamaica. Um, Laurie, are you on? She may have stepped away. Okay, there's a question. How do you balance fair housing laws? Ricardo Cox, if you could expand on that, how do you balance it, fair housing laws with respect to what?
I'm back.
Oh, Laurie Miller. Okay. Yeah, Laurie, I just wanted you just maybe for a minute or so. I did put your information as well as Neighborhood Housing Services of Jamaica and Brooklyn. They're certified housing counselors. Many times they're given money or have access to resources that can help homeowners with repair loans or grants. Do you want to speak on that just for a second or so?
Yes. So Neighborhood Housing Services of Jamaica is a HUD certified housing counselor. We offer a number of different programs for first-time home buyers. As Yvette said, we have access to information that the average person doesn't, and so we can facilitate access to programs like HPD's Home First, which offers down payment closing cost assistance. We also are funded by the state of New York through the homeowner protection program to assist homeowners who have fallen behind on their mortgages, try and get cure their delinquencies and stave off foreclosure. We also have a home improvement loan grant program. Right now, the funds have been exhausted, but we do have access to and information about other programs that are managed by other groups like ours throughout the city. So if you do have home repair needs, if we're not able to actually finance them for you, we can direct you to the appropriate parties. And we have partnerships with legal services, nonprofit legal services providers that provide assistance to homeowners like Legal Aid Society, Build Up Justice, um, JASA, which focuses on legal issues for seniors. So what I often say is if it's not something that we actually do, you should still give us a call if you don't know where to go, because what we can do is find you the right resource and point you in the right direction. Thank you.
Thank you, Laurie, for that. I know I just put you on the spot, but you know what you know, so I knew it would
No
be okay.
problem.
Yes, and I'll get to you in 1 second. I see someone has their hand up, but Ricardo Cox, to answer your question in the chat, how do you balance fair housing laws that says you can't discriminate against children's ages with conflicting window guard laws that require you to know children's ages? Okay, first of all, you can give a notice. Remember, it's documentation. So if I was in that situation, I can't ask the children's age. You're supposed to give a notice to your tenant and have them fill out whether they want window guards or not. There's one that says I do not want window guards, another one that says I have children under a certain age, so I do want window guards, and another one that says even though I don't have children under a certain age, I still want window guards. I would email that to them. I would have a witness somehow showing that I gave them this document. And if I never got it back, the onerous is on them. The burden is on them to have responded to you, and you're in compliance with number one, trying to get window guards for them, and without asking their age. Okay, the person that says JLJ's iPad here, you have your hand up.
Good evening, Attorney Dudley. Great seminar.
Thank
I
you.
have two quick questions. Last year, a law requiring lead paint testing via XRF test guns went into effect. What type of violation is that? What class? And is that HPD or DOB?
Yeah, Valerie, you can add to this, but Valerie, you want to take that?
Well, it's a HPD violation. Yeah, HPD, and you have to get it done, I believe, by January 1. So, or I don't
I
have.
thought it was last August. I thought it was August
No, no, no.
9th.
I'm saying at this particular point, it has been rolled out. So you have to be in a situation. If you do your registration, you see it on the registration. Are you familiar with that? You have to now do the, do that test. That runs about $1,000, that test. So they, have you started that process?
Yeah, it's not that expensive, but you laid out there's class A, class B, class C. Is that applicable to that type of
Well, I don't, I
violation?
don't think it's a C, but I can't answer that right off the top. I rather research
Mhm.
it just to see. I haven't seen what category they're putting it in. I just know that
Mhm.
now it's a requirement.
And
Okay.
if right, and if they come and find that there is lead-based paint, then that would definitely be a Class C violation.
Okay. All right. So my next question, have you ever heard of a situation where a violation exists on a property that says there's no C of O, but there's a C of O clearly posted on the DOB website?
If the C of O is posted on the DOB's website, and many times the Department of Buildings, when they're uploading their documents, I found many times that that certificate of occupancy belongs to another house. But if the certificate of occupancy belongs to that house, and DOB gave you something that said there's no C of O, I would just go to DOB and ask for a certified copy of the certificate of occupancy and present that as a defense.
So in essence, you get the proof
From the
from
Department of
from
Buildings.
the from them,
Yeah.
from the
Yeah,
okay.
yeah. I would go to they have a Brooklyn one, the Queens one on Queens Boulevard, but I would go to the Department of Buildings at just like if you're trying to prove an eviction case and you need those documents. I would get a certified certificate of occupancy and I would present that to oath to show, and you can do those hearings virtually, and I will upload their certified certificate of occupancy.
Even if even if you're not scheduled for an oath hearing, would that
Well,
have to be done at oath, or is it can
no,
you
then
do
maybe
it
I missed your
virtually?
question. I thought you said you had a violation for it.
Oh, I see. Actually, it's a violation that I saw. It's like 30, 40 years old.
Well,
And
maybe at that time there was no C of O. I mean, maybe something
mm,
there was a C of O predates the violation.
there's a C of O right after the violation because apparently there was construction being done where the C of O was being applied for.
Mm-mm.
And you see the violation, let's say the violation is in January and the C of O has an issue date in February, within 30 days of that violation. So I don't know if they crossed in the mail, so to speak, or if there was a cure that was supposed to be sent in, but there's clearly a C of O.
Right. You can definitely contact us afterwards so we could specifically look at that. There may have been a temporary C of O, right? So many times right before the C of O is given, a temporary certificate of occupancy is given to as a holding thing from the time construction is done
Mhm.
in between the sign off until that final C of O comes. So there may have been a temporary C of O that's part of the Department of Building records, or if there was no certificate of occupancy and someone started living there, the homeowner, or they started renting it out, then they may give that a violation for no C of O, because no C of O means no one can live there. So I would have to kind of see exactly what that violation says and kind of
Mhm.
help you address it more. Or also you can send me a private chat if you want, a DM, and you can give me the address. I can just look it up myself. Whatever is your pleasure. Okay.
Okay, thank you.
Mhm. And then we have Denise Muhammad.
Hello. I would also say this is an excellent presentation. I thank you so much. The question I have is, I know that they were requesting, and this has been some time, and I know they were doing it year by year with the sprinkler systems for 3-family homes. How is that working now? And is it a requirement for 2 families but have 3 levels?
Valerie, do you want to
What was
take that?
that question again? I was trying to get clarity on that. I know it's about the sprinkler systems.
Right. And I understand that the sprinkler systems were for 3-family homes. But also I was questioning the fact that how often do you have to have it renewed or inspected? And then the other question was, if you have a 2-family, is it required, although it's 3 levels?
Well, so did you have you rehabbed or something, did something different? Because anything new that's any new alterations like a alt one or alt two type of job, they are requiring some sprinkler systems. That's the new, code. I think we're on 2024 code, whereas before you didn't. So has anything changed with the property since you first bought it, or what have you
No,
done? So you haven't rehabbed it or anything?
no,
So you're just getting a sprinkler system just because you
no.
want
I
to?
had I had clients that people were reaching out to me
Oh,
because they had 3-family homes and everybody was panicking because they didn't want to pay that $10,000 fine.
okay. So it's just a three family. It's not like they have a basement apartment or they've done some modifications.
No, but then the other question was, there are homes that are 2 families. They're living as a 2-family, but they're 3 levels. So that's why I was inquiring.
Yeah, I'd have to look at that because I'd have to look at the code and zoning for the area and then see. So, because like even though there's like houses, but depending on where they sit, is depending on what the zoning says that they can do from the yardage to all kinds of little things. And then I would have to see why they have the sprinkler system. Like, are they using this for Airbnb? I've seen the sprinkler system requirement for people that are using them as Airbnb, 2-family or 3. So I just don't know enough to really say right off the
Okay.
top.
Okay.
Yeah.
Thank you.
But Miss Muhammad, if you could also send us your email as a DM, and then we'll circle back with you on getting a general answer for that. Again, things are very specific to houses. So if you found out a little bit more on that client's house or an address, then we could further assist. But you could send us your email and we'll circle
Okay.
back.
Thank you.
Mhm. And then we have Andrea in the chat. She says if a 1 or 2-family homeowner is not required to register their home, is there an advantage to registering the home? So I just want to make this clear because sometimes some of my clients may misunderstand that as well. For a 1 or 2-family house, if you're not living there, it has to be registered. So if you have a 1 or 2-family house and you're living there, it does not have to be registered. So I'm assuming your question addresses a 1 or 2-family house that's owner occupied. The owner lives there, and there will be no reason, no advantage at all to put yourself in the eyes of an agency when they don't have eyes on you. So no, there's no advantage in registering your home at all. You can collect if you're a homeowner and it's owner occupied for that 1 or 2-family house, you can collect rent, you can sue for back rent and everything. However, if you have a 1 or 2-family house, but you have a second home that's a 1 or 2-family house and it's not registered, you're required to register that house. And if it's not registered, not only is it a violation not to register it, if you have tenants there and they ever stop paying rent, you will have a problem in collecting that rent until it is registered. Andrea, if I didn't answer your question, you could definitely expand on it. Does anyone else have any other questions? Okay, thank you, Andrea. All right. If no one has any other questions, let me just put something up in the share my screen again real quickly. Wait 1 second. I'm sorry. think I lost that topic. um, yeah, I lost that topic. I wanted to share all the information. I see Aaron is also putting it in the chat for assistance with resolving your violations again. You could contact the Du Bois Bunch Center. We have the housing and real estate legal clinic every Wednesday via Zoom or in person. You can contact us at the phone number that's there, 646-470-8844, and you will have a one-on-one with an attorney to discuss your violation or any real estate issue for that matter, foreclosures, evictions, and everything, anything related to real estate. We also have all borough expediter Valerie Samuel. You heard her today. She's also willing to do a one-on-one session with you. And we gave you, I'll just put that in the chat very quickly. We gave you information on the New York City HPD, Department of Buildings, the oath hearings, and where you can get certain grants from. So I'll put that in the chat as well. And I just dropped it in the chat. Valerie, you have any closing statements?
I just like to say it's a great, privilege to be a landlord. And as long as you know everything that you need to know, or go to, a place where it can help you to get the resources that you need that are current on these kinds of things, you'll be in good shape. I didn't mean to like scare anyone away from it, but it can be costly if you do not, know exactly what you're getting into. So take advantage of the resources and the training that is available, like you're doing, and you'll be fine.
And to protect your home, again, if you own anything in New York City, I would constantly check on my home. I would constantly check on my deed to make sure I still own the property, because there's so much deed theft going on and it's only increasing nowadays. So I would constantly go to ACRIS, ACRIS, and check on my deed to make sure I still own the property. And I would register for notifications. Therefore, if anything on my property moves, I would get a notification from the city of New York. I would go to HPD. If you own something that, especially if you have a tenant, I would go to HPD and continuously check for violations, as well as the Department of Buildings, and continue to check for those violations. Okay. And again, if you need someone to address it, you will contact one of us. I sincerely thank you for spending your evening with us and listening to our information. Hopefully you have signed up and registered for this program, so you are on our mailing list. We consistently, every month, we're giving a program to try to enlighten the community about protecting their homes and preserving their homes. I hope everyone has a wonderful night. Thank you and be well.